will be here in the Saxbe Auditorium, so we've got you covered all week for lunch. We do have dues that you don't have to pay them to come to our events, but if you want to vote in the election for next year's officers, we need you guys to pay those by January. We won't get into specifics about that, but you can see that our treasurer, he'll take care of you with that. So on behalf of the Federalist Society, our event today is called Judicial Elections, and it features Professor Jacob Huebert of Ohio Northern, as well as our own Professors Tokaji and Ric Simmons. Since we haven't really done a panel discussion yet, this is the first one we've done. Mostly we've done the debate format. I'll give a brief overview of what the panel discussion setup is going to be. We'll have a statement by Professor Huebert, then followed by a statement by Professor Simmons, and following that, we'll actually turn the ball over to Professor Tokaji, and he'll kind of lead the panel, and we'll get the discussion going from there. And then, of course, with time that we have, we'll take questions from the audience. I'll also give a brief introduction for the speakers today. You guys already know Professor Tokaji, so without going too into that, we'll just get started with the biographies of the two speakers we have. Jacob Huebert is an attorney, law professor, and the author of Libertarianism Today. His articles have been published in newspapers around the country, including the Christian Science Monitor, Baltimore Sun, St. Louis Dispatch, and many scholarly and professional journals, and most importantly at LukeRockwell.com. As a law professor, he teaches jurisprudence, payments, and advanced appellate advocacy at Ohio Northern. He also teaches appellate advocacy right here at Moritz, so you probably have him as your adjunct professor. He's also an adjunct scholar at the Ludwig von Mises Institute. Professor Huebert earned his bachelor's in economics at Grove City College and his JD at the University of Chicago Law School. After law school, he served as a clerk to Judge Deborah Cook in the U.S. Court of Appeals for the Sixth Circuit. He practices here in Columbus and has been recognized as a rising star in appellate law by super lawyers. He is also the president of the Columbus Lawyers Chapter of the Federalist Society. And Professor Ric Simmons, probably well known to you guys, is a graduate of Columbia Law School, where he was a Stone Scholar and a senior editor of the Columbia Law Review. Following law school, he clerked for the Honorable Lawful Waters of the Central District of California. Professor Simmons served for 4 years as an assistant district attorney for New York County and was an acting assistant professor at NYU School of Law from June 2000 to 2003. Professor Simmons is also the creator and editor of the website ChooseYourJudges.org, which assists voters in choosing candidates in judicial elections. The website allows voters to take a quiz to determine their preferences for the type of judge they want, and then provides a recommendation based upon those preferences. The website also contains commentary about the judicial election process and has a blog with current news regarding judicial election campaigns. Here at Moritz, he teaches evidence, criminal law, and the prosecution practicum class, and he's also the author of the critically acclaimed book on evidence called Learning Evidence from Federal Rules to the Courtroom, which is probably why he's got some street cred. Sadly, he is a Denver Broncos fan. They were on a bye week this week, but I am convinced that they will not win more than 2 games from this point on. And with that, I will turn. Hey, I'm an Eagles fan. We're rude. I will turn it over to Professor Huebert to give his beginning opening statement, and then we'll start from there.
Well, thank you. I'm here to speak on this topic because I've written a new paper for the Federalist Society, the National Federalist Society, on judicial elections. I studied the whole history of judicial elections, and how we choose judges in Ohio, challenges to our current method. And in studying all of this, I reached 2 basic conclusions. One is that Ohioans are never going to get rid of judicial elections, and the other is that there's no good reason why they should. And to see why it's so ingrained in Ohio's political culture, and why it may be a good reason to have judicial elections, it may help to look at why the delegates to our 1851 Constitution chose to choose that method of selection. The kind of conventional wisdom that one hears repeated about this is that democracy was just kind of a fad in the mid-19th century when we did our Constitution. People just liked democracy or not. They thought, well, democracy's good, then we should have elections for everything, including judges. But there's been some scholarship that says there are some more specific reasons to want elections with respect to judges. University of Virginia professor Caleb Nelson has identified one of them, which is limiting government power. And if we look at what the 1851 Constitution delegates did, they very much had that in mind. And we can see why elections would tend to limit government power. If the governor, or if the legislature gets to choose who the judges will be, well, of course the governor or the legislature is always going to choose people who are going to tend to uphold as much power for them as possible and just affirm whatever they want to do as much as possible. We can see this at the federal level, right? Would the president ever appoint a Supreme Court nominee who takes a very constrained view of executive power? Or would the Senate ever approve a nominee who takes a severely restrained view of Congress's powers, say under the Commerce Clause? Well, no, they check to make sure that they don't hold those views, and as a result, the President and the Congress get to do pretty much whatever they want with very few limitations. Well, when you have elections, at least someone from outside the government can come in, the existing government can come in and have a say, so when they're doing something that oversteps their bounds, they're held accountable. And that's definitely what the delegates in the Ohio Constitution had in mind. When the delegates went into the Ohio Constitutional Convention, everyone kind of knew in advance that they were going to go with judicial elections. There was popular demand for it, and so there wasn't any debate over whether they would do that. But if you read these debates, you can see them break down into two basic camps. One that's only grudgingly going along with this, and one that really wants it. And the people who are, and you can tell this from related judicial selection issues, like when they're talking about how long a judge's term should be. The people who don't like elections at all want judges' terms to be really long, so we have as few elections as possible, and people who like elections want them to be short, so we can have as many elections as possible. And when they debate this stuff, they're debating as though they're debating the whole issue of whether we should elect judges at all. And what you see is it bears out very much Professor Nelson's ideas about why all these states across the country around this time did this. For example, the one group that didn't like elections was the Whig Party. And they were essentially the intellectual descendants of Alexander Hamilton and the Federalist Party, and took the view basically that government should be as centralized and relatively powerful as possible. The people really can't be trusted very much to govern themselves, and really should kind of submit to rule by their betters. In general, that's kind of a caricature, but that's the general take of that camp. On the other hand, you have the Democrats, who are essentially Jeffersonians, and who think that power should be decentralized, that people can be trusted to govern themselves, that individual liberty should be the aim of government. They were essentially classical liberals or practically libertarians, and so they thought that their ends would be well served by having elected judges. And so we see with the Whigs quotes that reflect their view that they don't think that people should have influence over judges. Quotes like this one. How can a judge take the solemn oath to discharge his high office without fear, favor, or affection? He who is constantly in dread, who's trembling at every step, lest his decisions may not be acceptable to a popular majority. They also said that the judges would then be beholden to, quote, the whims, caprice, and fluctuations, end quote, the popular opinion. But the Democrats responded to this by saying that the Whigs had it backward. They had the whole idea of what government in America is supposed to be about, because their setup was based on not trusting the people. But our government institutions should really be set up in a way that reflects distrust of government officials. And so that's why they thought that elections were appropriate. And one of them, Democrat delegate Charles Greenland, expressed their view of government this way. The mere machinery of government, unless aided and acted upon freely by public opinion and an enlightened people, has always done a good deal of harm to the people, but seldom accomplished for them any good. I have little confidence that in that vaunted legal talent, experienced age, independent courts, etc., unless backed and kept alive by Republican habits and a perfect equality among all classes of the people. Well, the Democrats won in the end, and we have judicial elections, and people were pretty satisfied with that for the second half of the 19th century. Then at the beginning of the 20th century, we had a new strand of thought in American and Ohio politics with the progressive movement. And the progressive movement had two ideas related to how we choose judges that are especially relevant. There are lots of strands to the thought, but two in particular that are relevant here. One is that they wanted to decrease the role of political parties. They saw them as corrupt, as serving powerful interests, and so forth, and so they wanted to decrease political parties' power. The other was to have a society run as much by possible as experts, who could just kind of, run everything for us and tell us what's best, because after all, they're the experts. But this dovetailed nicely with the legal profession's view of itself, which had changed over this period of time. And the lawyers' opinion of themselves had greatly increased during this time, and they were very happy to be recognized as the experts they thought themselves to be in this kind of new science they believed of law. And so they were ready for the progressives to appoint them the experts to decide who our judges would be and make a good legal system for us. Now in Ohio early on, they didn't go so far as to just put lawyers in charge. They switched the system around a little bit so that we would have direct primaries instead of what we used to have where the political party would just get together in a convention and decide who the candidates would be. Now voters would vote directly. And lawyers were okay with this because they thought it would increase their power. They thought, well, surely voters will listen to us and vote for who we tell them to vote for because after all, we're lawyers. Who wouldn't want to listen to us? And it turns out they were over-optimistic about this. They were wrong. They didn't like the results. And so they had to come up with something else. And in the meantime, there was another idea that came along, the Missouri Plan, as it's called now, because Missouri was the first state eventually to adopt it. And under this Missouri Plan, there's variations on it, but the general idea behind this Missouri Plan is the governor appoints a commission, a panel of people who will nominate judicial candidates. And then the panel will send out a list of nominees to the governor. Whenever there's an opening on a court, the governor will pick the person will take the bench, and then maybe every 6 years or so, there'll be an election where we decide whether we should keep that judge on the bench or not. And people will vote basically yes or no on that. And lawyers like this because they thought, they're going to be in charge basically of who's on these judicial nominating commissions, and then they can really have the run of things by getting this in place. You can see their motivation by this. They were very open about it. When the Ohio State Bar Association met to consider this first in 1934, you had an Ohio Supreme Court justice. Well, the two reasons were, one, to increase government power, and two, to make sure that lawyers were in charge of that power. And they were open about this. One Ohio Supreme Court justice said, quote, "The people of our state are rapidly becoming conscious of the fact that they've gone too far toward pure democracy. They have seen unmistakable signs of the usual resultant inefficiency. There is a growing demand for more social discipline and more authority in government, and the first step toward the realization of that end is a strong and independent judiciary." Then you had Newton Baker, who gave his name to the Baker and Hostetler law firm, who also favored this and thought that Ohioans could be persuaded to give up judicial elections if we just gave them the right message. And that message he thought we should deliver was, quote, "You have no capacity. You could not readily acquire the knowledge to choose judges wisely," end quote. So they put it on the ballot in 1938. As it turns out, Ohioans weren't all that receptive to the message that they have no capacity. They rejected it by a 2-to-1 margin. It failed in every county in Ohio. It stayed dead for a long time thereafter. The Bar Association's chairman was kind of tried to figure out where they went wrong after this. And he thought maybe it's because of the New Deal, which hadn't been working to cure the Depression, so people didn't want new experiments in government. And he thought maybe people were looking to Europe where fascism and communism were taking over, and they were afraid that giving up their right to vote would be kind of like a step in that direction. And then he also said that it looked too much like people thought it was a power grab by lawyers, and that's why they didn't like it. So next time we need to get some other people involved in this so it doesn't look that way. But of course, they were just trying to hide the truth, which was they wanted to put themselves in charge of this process. So for the next 50 years, they tried and tried again to kind of get something going, but it never took off. In 1987, they got it back on the ballot because there had been a lot of controversy at the Ohio Supreme Court. There was a Chief Justice, Frank Celebrezzi, who had kind of brought disrepute upon himself in the court by behaving what most people would consider to be rather badly and obnoxiously. So they thought this was their big chance. And surely, if they were going to have a good chance, that was it. But the exact same thing happened. It failed by a 2-to-1 margin all over again. 80 of Ohio's 88 counties rejected it. And the advertising, the TV advertising in that campaign goes a long way towards showing why this thing's never going to succeed. The people who supported elections, that all they had to do in their ads was say the same thing over and over again. Don't let them take away your right to vote. And they showed a voting booth with a bunch of chains around it and a big padlock. And that tells the voters everything they need to know as to why they shouldn't support this measure, right? I mean, that's